Welcome back. Now, reactions have not stopped trailing the move by the president to grant anticipatory approval for the purchase of military aircrafts from the U.S. government, with the hope that the lawmakers will raise no objections. Lawyers still remain very sharply divided over the correct interpretation of Section 82 of the Constitution. We have some more of those reactions up next.
I beg to disagree with those who are saying that Mr. President cannot proceed to buy the jet as being circulated around the town. What my own position is this: if Mr. President finds out the need, being the #1 security officer of the nation, that the security situation of Nigeria is in breach and there is a particular situation or opinion to quench same, Mr. President could think and deem fit to make sure that he gets whatever he needs, maybe from the Senate, whether they grant or not, whether public opinion or not, whether they want to follow any. What's important is to quench the situation so that the people that has voted for him will not see their life being lost.
The president was wrong, because clearly this money, it's part of the money that is generated as a state revenue. You know, the Consolidated Revenue Fund requires that every money that comes to the state, you know, it's collapsed into the revenue fund of the state. So to that extent, every money that belongs to the state must be spent based on appropriation. So like in the circumstance like we have in this current expenditure being made by the executive, having regard to purchasing of jets, you know, you cannot resort to spending state funds, in this case the money that belongs to the Federal Republic of Nigeria, without necessary appropriation by the National House of Assembly. And beyond that, I know the argument has been canvassed that there was a doctrine of emergency, let me put it that way, or a doctrine of necessity, where the president now have to act based on the recommendations or approval of this Council of State, which comprised all the retired presidents, the current head of states, you know, the highest judicial making authority of the state, which is the Council of State, where that he got approval from them. But the Council of State is not the National Assembly. We cannot relegate the function of an institution like the National Assembly that is responsible for, you know, such appropriation. You cannot otherwise usurp the function of a National Assembly as against the function of the Council of State. So I don't see the emergency there. But what they are trying to do now really is to do a ratification of what has happened. Ratification is like placing the cart before the horse.
Well, practically speaking and constitutionally speaking, the president has not done anything wrong. He simply took a step that was necessary to keep the country moving. Don't forget, we are talking about security matters. And that is precisely the essence of Section 82 of the Constitution. It is to allow the president to make spendings while we are still waiting the National Assembly to approve the budget. As long as what he is spending does not exceed what was approved in the previous year, what he is doing is right. And if you are talking of the budget, which budget are we talking about to start with? It has not been approved. So as we speak today, there is no act of the National Assembly that you call the budget for 2018. So what you will have to rely on is what was spent last year. And as long as he has not exceeded that amount, what he has done, there is nothing wrong with it.
Now, there's no doubt that the court will again have to weigh in on this issue to give the correct interpretation once and for all. But we'll keep our eyes on how things play out, follow the issue closely, and keep you updated on the developments as they unfold. Let's now check out some of the top trending stories from the courtrooms.
We begin with the reports that a federal high court sitting in Abuja on Thursday the 10th of May nullified the Senate's suspension of the senator representing Delta Central, Senator Ovie Agege. Justice Nnamdi Dingba held that while the National Assembly had the power to discipline its erring members, the premise on which Agege's suspension was anchored was illegal and unconstitutional. In the words of the court, the suspension of Senator Magige for filing a suit against the Senate constitutes an affront to the judiciary. Access to court is a fundamental right in the Constitution which cannot be taken away by force or intimidation from any organ, and that's according to Justice Dingba. The justice also added that even if the Senate had rightly suspended the senator, it could only have suspended him for only a period of 14 days as prescribed in the Senate rules. The judge therefore nullified Omagige's suspension with immediate effect and ordered that the senator be paid all his allowances and salaries for the period he was illegally suspended. The Senate had on April 13th suspended the senator for 90 legislative days over his comment that the amendment to the Electoral Act 2010 seeking the reordering of the general elections was targeted at President Muhammadu Buhari. Meanwhile, the Senate has filed a notice of appeal and a stay of execution of the judgment. Staying with cases involving senators, the trial judge in the bail application of the senator representing Kogi West, Dino Melaye, has reserved judgment till the 16th of May. Justice Nasir Ajana fixed the date after listening to arguments from the lawyers in the matter. The prosecuting counsel, Alex Izion, had told the trial judge not to grant the bail application as the defendant had been certified fit to stand trial. He filed a counter-affidavit to the effect that Senator Melaye had made an attempt to escape by jumping out of the police van, taking him to Lokoja. The defense counsel, Mr. Michael Zekome, in his response, said the senator managed to run away from the scene after being tear-gassed, adding that someone who wanted to escape justice would either run to his village or any other place where he will not be easily reached. But in Melaye's case, he ended up at the National Hospital, Abuja. But the prosecution countered by insisting that the defendant had not been able to prove that the alleged ailment was beyond the responsibility of the prison. Mr. Izian also submitted that the senator was only feigning an ailment after he attempted to escape. And yet another senator has a case in court. The senator representing Ogun East Senatorial District, Buruji Kashamu, has approached the Supreme Court asking it to enforce his rights. Through his lawyers, he filed 2 notices of appeal at the Supreme Court, urging it to set aside a Court of Appeal judgment which dismissed his fundamental rights suit. At a press conference held in Lagos after filing the suit, Senator Kashamu told journalists that the Court of Appeal erred in law and occasioned a miscarriage of justice by dismissing his objections. The senator also argued that his affidavit before the Court of Appeal was full of facts showing the conclusion of a plot by the Attorney General of the Federation and others to abduct and transport him to the United States to face trial over alleged offences in respect of which he had been exonerated. He argued that the Court of Appeal was wrong in assuming that he ought to wait until the plot to have him abducted had been executed before he approached the court for redress. The senator also took a swipe at certain interpretations given to the Court of Appeal judgment. He urged the Attorney General of the Federation not to allow his office to be used to punish an innocent Nigerian in a bid to satisfy the desire of some political opponents or external forces whose interest is to seek and gain political advantage. Away from the cases involving senators, we move to Lagos, where the state government is set to prosecute the 53-year-old Danish man, Peter Nielsen, who allegedly killed his 37-year-old wife, Zainab, and his 3-year-old daughter, Petra. The Chief Magistrate of the Yaba Chief Magistrate Court made this known on Tuesday while reading in open court the advice issued by the Department of Public Prosecution, DPP, Lagos State Government. The Chief Magistrate also granted a further remand of the Danish man for another 30 days to enable the police and the government file criminal charges of murder against him before the appropriate court, which is the State High Court. The matter was then adjourned till June 28 for its possible arraignment at the State High Court. The defendant, a Denmark citizen, was alleged to have killed both his wife and daughter at their residence situated in Ikoyi, Lagos on April 5. He was also said to have hit his wife's head against the wall several times, inflicting fatal injuries, and later poisoned his daughter while trying to cover up the murders as a domestic accident. The wife, Zainab, is a Nigerian singer popularly known as Alizi. Family and friends of the victims, alongside dozens of human rights activists under the auspices of a non-governmental organization, Women Arise, besieged the court in black t-shirts with the pictures of Zainab and her daughter. They carried placards denouncing the growing menace of domestic violence in the country. And we round up with the report that the National Judicial Council, NJC, has set up committees to look into the allegations leveled against some 25 judges. Mr. Ye also says that the NJC recommended the compulsory retirement of a judge of the High Court of Adamawa State, Mr. Justice Michael Goji.
And it's on that note we wrap up today's episode of the program. Please feel free to send in your comments on any of the issues we discussed today. Do also remember that you can watch this episode and past episodes of the program on our YouTube channel. I'm Shola Sheyeli. Many thanks for watching.